the DA by the DA's submission of the application for leave to appeal, that it might suspend the judgment, but does it then reinstate the acting public protector? Because her term, in terms of the presidential minutes, had expired at 2:30 on Friday, as it would have if it was the 14 days or whatever. So on the 15th day, a new act of reappointing her would have had to be made. And as I say, it doesn't matter if it's, for the purposes of this point, whether it's 14 days or 12 days or 2 hours or whatever. So that's where we say there's no locus standi, coupled with the fact that this court has held that she is well, she cannot act for the she's not the public protector of South Africa. So that's the locus. Even if we're wrong on that, the real point is, and it's coupled to this, what is the test? I've never heard of this test that Mr. Brainers is telling us about, the need to put the facts or whatever. The test is very simple. The test is whether you have a substantial legal interest in the subject matter of the litigation. The subject matter of the litigation here is the Section 18 application. And that goes directly to
putting into operation the order.
The order of this court, yeah. So what interest, that goes to Justice Likulene's point, the only interest that the acting public protector, so-called, can have that is to stay in that post for as long as humanly possible. And surely that's a conflicting interest, because it's not like she's just some neutral South African who has nothing to gain by the non-operation, let's call it like that, of the order. The longer the order is not operational, the longer she stays as the acting public protector. So Justice Likulene hit the nail on the head. And what that interest, quite frankly, it's fine if we all want to hold offices. So, but that is not the legal interest that is defined in the rule. Certainly is not. And just quickly, just for the sake of progress, go to D1-139 of Erasmus. I hope this is, oh yeah, it is 2021. D1-139. That's the commentary on Rule 12. It says, Erasmus says, as in the case of joinder, as of right, the applicant for leave to intervene must show that he has a direct and substantial interest in the subject matter of the action. Okay. The authority for that is a case called the Henry Viljoen versus Bush Brothers. It's an old case, 1953, 2 SA 151, but that has been, sorry, I've just missed it. And 51O at 167. But it has been confirmed in many cases, including in the Constitutional Court, SA riding for the Disabled Association, otherwise known as SARDA. I think we referred to it the last time we were here. National Land Claims 2017-5, SA 1, Constitutional Court at 4F. It's a well-known test in the subject matter of the action. Such an interest is more than merely a financial interest, which is only an indirect interest in the litigation. I pause there. So any indirect interest in the litigation is not sufficient. Here we don't even have an indirect interest. What we have is at best a conflicting interest. And then it says, it is a legal interest in the subject matter of the litigation that may be prejudicially affected by the judgment of the court. And let's pause there. What interest may be prejudicially affected by the judgment of the court that belongs to the Deputy Public Protector, except the one that was asked by Justice Likulene? This means that must show that he has a right adversely affected or likely to be adversely affected by the order sought. So the order here being the section 18 order. So even if you, let's leave out the factual stuff, let's leave out that it's just an unwarranted and gratuitous attack for stating, neutral facts. Let's leave out the technicalities about whether the public protector was reinstated at a particular time and so on, and whether there's local standing. Let's just go to the nub of the issue. What is the interest that is required by the law for this kind of application? For this court, and really we have to apologize to this court for what is clearly an abuse, because to have a 30-page affidavit with tables and chapter and verse about how many reports were finished in what month, what's the relevance of that to the issue before this court? Zero. Put aside the 400 pages of evidence, we'll talk about that later, that is put up by the DA coming from the section 194 inquiry. But it's just an abuse of process. This is an urgent court. The reason why we did our affidavit to be 14, 15 pages is because we could have gone on and give historical accounts of this and the other. But we knew that this is urgent court. We need to come and say what we have to say and get out, and not tell this court about all sorts of long stories. And we have lots of them about this matter. But it was crisp. Go in section 18. We met the requirements, yes or no, and let's move. I don't even want to tell you what is contained in that affidavit, but that's why we did a Rule 6 deeply, because we said, let's assume all those facts are true, assume all those tables are true. So what? What has it got to do with what we're debating here? Number one, so it's not relevant. B, it certainly doesn't conform with Rule 12. So, and we would like the court. We don't have to ask for punitive costs and things like that, because again, we don't want that kind of acrimony. But the court must please, whenever it makes a ruling on this, just express its displeasure at what now has turned out to be. We ask for this court, we beg the judges to come earlier than the normal time, and the judges indulged us. But now all that has been cancelled by something that is completely unwarranted. And this is not the first time. This last time we had the same thing about Siametho and the attorneys and joiner and the definition of PPSA and so on, which had nothing to do with the business that we were about here. So if the court doesn't put a stop somehow to this, then it means that it's just going to happen again. It's bad on every front. Public protector, the acting public protector, deputy public protector, whatever she is, she must sit, wait, and when the outcome comes, whatever it is, then if it favors her, it favors her. If it doesn't, it doesn't. But you can't induce a particular type of outcome by trying to paint unfairly and unreasonably so about the actual public protector as somebody who, I don't know, misled the court or has put facts that are not that are not true, because they are true. People did much, and they say in much stronger terms that she has delayed the matter. It doesn't matter if that is true or not. You simply say that's their perception. That's why they marched.
Reynolds, you have to short reply.
Thank you. Lord, in deciding the execute application, the advocate Mkhwebane said in the affidavit that part of the reason that you must never leave to execute is because she makes, as we say, 3 allegations. Those allegations are denial of access to crucial documents and delay and destabilization in investigations. Now, those are factual questions which my lords must decide, my lords must determine. Lords must ask themselves, is it correct that there is a situation alleged by the Advocate Mkhwebane that requires particular action? Now, the allegations on which he relies, the acting public protectors are not true. And the acting public protector says, in order, here are the true facts, so that you, the court, can make a proper and full determination. It's surprising that our learned friend says, well, what does it matter whether those facts are the truth? And that's a rather cynical attitude towards the court and the truth. It does matter that it's the truth. Because, of course, we're dealing here with a Chapter 9 institution, a public institution, and we're dealing here with the right of Advocate Mkhwebane to get leave to execute. It is important. The true facts must be available so that my lords can decide whether on those facts leave to execute should be granted. Saying that the acting public protector doesn't have direct substantial interest, we say she is by law the incumbent and therefore has a direct and substantial interest in a finding by the court on the conduct of investigations in her office. She has a direct and substantial interest, in fact, in the finding by the court that her office has denied Advocate Mkhwebane, who has a right to crucial documents, that it's denied that during the inquiry. So, my lord, she obviously has a direct and substantial interest. But finally, my lord, and we come back to what we said at the end of this. You're concerned ultimately with truth, and you do so by applying independent, impartial minds. It seems to us that under our constitutional dispensation, our courts are particularly concerned that they decide matters on the true facts, and that organizations like the Public Protector Office places before court to assist court to come to a just decision. And those are reasons, my lord, why my should allow intervention or permit intervention and admit the affidavit. Thank you.
Thank you, Mr. Brandes.
Yes, I apologize, my lord. There's just one small thing that I forgot to mention. My learned friend said that earlier in his address that the application is not frivolous. I've addressed that, but I just want to point out one thing just so that we can see what we're dealing with here. Look at the heading of the application that has been brought. The applicant is page 816. The applicant is the Public Protector of South Africa. And then it says the first respondent is the Public Protector of South Africa. And then in red, the Public Protector of South Africa versus what is that? So the Public Protector of South Africa, and that's only one person, that's Mkhwebane, is suing the Public Protector of South Africa as a first respondent. I mean, and that's to try and escape the effect of the earlier judgment of the 9th of September. If that is not frivolity and wasting the time of the court, then nothing ever will be. And again, as far as the documents in the office, it's common cause. It was raised, it was resolved, but one cannot escape the fact that all the public is saying that because I now have to go via asking people to get documents, I'm now affected in the section 194 inquiry. That's all. It's not a blame. blame game of anybody. So this application should be dismissed with some serious censure of some kind.
Thank you, Mr. Bo. We will consider the submissions relating to the application to intervene and deal with it in our judgment. We may now get into the main matter.
Thank you.
And just to facilitate the main matter, may I ask if there is still any party which seriously opposes the issue of urgency, so that we decide whether we spend time on that or whether we get on with the matter.
My Lord, we persist with urgency, but we are content to argue it in the course of things. We don't seek to raise it as a point.
Thank you, Madam. We haven't raised it in the system, but in our head,
All right, you may then proceed.
Thank you, Madam. Thank you very much. That actually assists me, that question. What I will then do is I will not address the issue of urgency, because likewise we have addressed it exhaustively, both in the heads and in the founding papers and the supplemental papers and the reply. And it's also
Sorry, I didn't give Mr. Ngalwana an opportunity to comment on that.
You might want to oppose.
I'm sorry, Mr. Ngalwana.
We do not oppose. We did want to make one or two submissions in relation to the international application, but we missed the point to accept that.
And that vote has said.
The only thing I want to say about the agency, for what it's worth, is that it's just to flag to this court that the fact that the so-called application to the Constitutional Court by the DA says that the matter is urgent. So apparently their application to the court is urgent and it had to be done within a few hours. But ours, when we react to that, is not.
And then on the issues, it seems as if the issues have kind of crystallized into, firstly, the issue of Section 172.2 and whether it applies. Because if it applies, then the question would be, would Section 18 be applicable?
Yes. That's, let's call that the preliminary issue, and then the merits. Yes, that's correct. That's correct. In fact, yes, that was the judge took the words out of my mouth to say that there are actually two separate issues. One, let's call it the preliminary point, which is the Section 172 stroke Section 18. I think it's been articulated in the DA answer affidavit as follows: whether Section 18 applies, and then you take it backwards to 172 and so on and so on. Then, of course, the second issue is the merits, whether the test has been satisfied. Let me start with the first issue, because that's the one, there's so many smokes and mirrors around it. But we're going to try and simplify it as much as possible. Again, let's keep the eye on the price. The price is, does Section 18 apply to this matter? That's because if it doesn't, well, then that's the end. We must all go home. And then if it does, we deal with the merits. So the argument then goes something like this. The order that was given by this court, they say, is an order in terms of 172.2. And when I'm talking broadly about that section, I'll just say 172.2. There's going to come a time where I differentiate between A, B, and C. And we say, no, it's an order in terms of 172.1. So that's the first departure. Then, the reason why that is important is the implication of what, as we move towards the price of the applicability of Section 18. they say that if it's an order 172.2, then it's subject to confirmation by the Constitutional Court. We say that the order is a 172.1 order.
Can I interrupt you that I don't quite understand that, because my understanding of the scheme of that section is that an order made in terms of section 172.1 carrying conduct to the constitutional.
What is 172.1A?
Yes.
Yes.
Is not effective until confirmed by the Constitutional Court. Yes. That's what section 172.2 says.
Yes.
That's what section 165 says.
Yes.
So it's not an order. There won't be an order in terms of section 172.2, but it will be an order in terms of section 172.1.
Yes.
And then 172.2 talks to that.
Yes. Okay. Fine. Let's assume that is so for the sake of progress. Then the point is this still. In fact, I think Mr. Butler, either in his answer or affidavit, or says that it's both, which is what I think they're saying, Justice.
No, I just want to
explore,
so that you can clarify that for me if my understanding is correct or I'm missing.
No, fair enough. Yes, because it has been raised. But I'm saying I really don't want to waste the time of this call. I'm saying let's assume that is so. Let's assume this is an order of invalidity. We strongly say it is not for various reasons, including the fact that it derives not just from the constitutional invalidity, but also from the common law and so on. We've made those points. We say that at best that order is a hybrid order that talks to even if you accept that decision and conduct, again, I don't want to enter that debate. Let's assume the decision and conduct is synonymous for argument's sake, which again we deny that is so. But for the sake of progress, let's say that's the same. So even if you accept that, then you have to accept as well that the order comes from two things. Let me postulate it like this. Let's assume this court had said, Mr. Mpofu or public protector, we're not interested or not going to find actual bias. And we're also not going to find a reasonable apprehension of bias, what we call the common law bias. And the court said the only premise upon which we are succeeding is section 96(2) of the Constitution. Then that would clearly be a quintessential 172.1A order, which is based on the constitutional violation of conduct, and therefore 1B, and on the formulation we've just now agreed for the sake of good governance, which flows to 2B. But that's not what happened here. And that is actually another crucial distinction between this case, for example, and EFF Ghana. Because in EFF Ghana, the premise of the conflict was 96B. That was it. Here, we have a hybrid situation where there's a 96(2)B conflict, but there is common law conflict based on actual. It doesn't matter whether it's actual or reasonable apprehension for the purposes of this argument. Both of them are derived from the common law. Now, what we say is that, take my example and flip it backwards. So the public protector, therefore, theoretically could have come here and say, I'm just coming here on the question of reasonable apprehension of bias. Forget the Constitution, throw it away. I'm saying there was a reasonable apprehension of bias, and therefore the suspension should be set aside. That's it. That is competent. It's something that it should have done. or rather she could have done. The mere fact that for the sake of proper pleading, you lump all those things in one set of papers is irrelevant. There's nothing which could have stopped her from saying, I'm here only on the common law bias or actual bias or reasonably perceived bias. Then we wouldn't be having all these debates about 172.2 or this one or that one. It would be a matter of setting aside the issue because the common law rule has been breached. Full stop. Okay. So let's park that. I'm even prepared to concede that. You'll see how I'm going to make this so easy. Let's assume I'm wrong in all that. There's no common law element. It's all 172.1a. The question is, so what? Because the even on their version, my lords, even on their version, we should place this as a 172.2a matter. Then this is what that section says. Sorry. So let's say for the sake of this argument now that this is a 172.2a order. Maybe let me pause before I do that and explain something which is also crucial. This order that we are debating now, justices, must be understood in the context of the judgment. We all know it's Law, Firestone versus Cherry Court, I think it's the case that says a judgment, an order must be interpreted like any other legal document, and using the reasons as the surrounding circumstances. Now, the order at 187.5 is the only order that can conceivably be called a 172.2a order. And that's the declarator. There's no doubt about that. So the decision of the president, let's say, the decision of the president to suspend the applicant is hereby declared invalid. But what has all that got to do with the order at 187.6? The order at 187.6 says the suspension of the applicant is hereby set aside. And then it says effectively from the date of this order. So we've said in our replying affidavit, that order is what we know as a compound order. There's nothing compelling the court to separate its of style to separate the orders. It could have put one long sentence if the court wanted. So, but because we're here now, we have to dissect this order. The first part is the suspension of the applicant is set aside, full stop. And then there's it could have been a 187.6a or b. The effective date of this order is the 9th of September. That's really all that's communicated there at 187.6. Now those two orders or sub-orders combined into one cannot, in anybody's language, be called 172.1b orders. Here's the catch. Again, the court will know just from its own experience. The public protector, it happens here, it happens in the labor court, it happens everywhere, could have just come to this court and say, I only want one prayer to set aside the suspension. That's it. And nobody would have said, no, but why don't you first ask for a declarator? She said, I don't want it. I just want to set aside the suspension, as happens every day in the. Now, who would have then said, no, that order setting aside the suspension must be confirmed by the Constitutional Court? Nobody in their right mind. Now, So it's important to distinguish between these two, and that's where this issue of the common law is important. It's important because, again, that order derives again in their favor. Let's say somehow it's also the 172 declaration. But there can be no doubt that it also derives from the common law findings of this court. And with the greatest respect, we say that it is rather disingenuous, and we use that word advisedly. We say this at paragraph 27 of our heads. 23, sorry, page 6. So it is disingenuous for the respondents to deny at this late hour that the said conflict was specifically pleaded on the basis of two common law grounds, namely actual bias and or reasonably apprehended bias, and separately upon a constitutional ground, namely section 96(2)(b) of the Constitution. There's no doubt about that. There has never been any doubt in anybody's mind. You might remember, I even said, criticizing the court, the Part A court, because it actually did the opposite of what my learned friends are now saying. You take that judgment of the Part A court, you will not see the word section 96(2). It's not there. So, and we said that was what we had pleaded, but it has not been addressed by that court. That we were doing that for the purposes of making a separate argument. So all the court did was simply to address only the common law bias grounds. So for these parties who have been the biggest supporters of the Part A judgment, to now come here and say that that judgment, which was based on the common law specifically, was not based on the common law, that's complete disingenuous. And then we say that this distinction was highlighted in both Part A and in both the Part A and Part B papers and arguments, even in this court, as I've just illustrated. It was never disputed. This is further, we say this is further illustrated by the following dictum of the Part A judgment, which the respondents have always roundly supported. And sorry, we didn't put the part. It's paragraph 103 of the Part A judgment, which we criticize for this very reason. This is what the judges said in Part A. The applicable legal principles on this issue, in other words, on the conflict issue, emerge from the common law. They have since been re-articulated in the right to a public hearing under Section 34 of the Bill of Rights and in a sequence of appellate division judgments. And I think they wanted to say constitutional court, because if you see the footnote, it's only constitutional court judgment. Then says, consequently, contrary to what is contended by the incumbent, she, in other words, this was used against the public protector, now it's almost being weaponized against her. She is not possessed of a freestanding claim for the refusal of third respondent, independent of the common law principles as set out in our jurisprudence. That's what was found, exactly because we had pleaded the common law ground as well as the constitutional ground. Our only criticism, at least before this court, was that that court only concentrated on the common law ground and did not address the other leg of the but now the script is now being flipped to say, no, this has nothing to do with the common law. Now, so the reality is this. If let's assume again that the Part A court has found in our favor, if it had done so on the way that the judgment is formulated, it would have done it so purely on the common law ground, which it has articulated in its paragraph 103, and it would not have made any reference to section 96. Now, if that does not illustrate the fact that the order in 187.6, at best for them, derives from the constitutional ground, but also derives from the common law ground, then nothing ever will. And the importance of that, my lords, is that that order has a life of its own. It's not ancillary to the order in 187.5, as it is said. In other words, it doesn't flow from it symbiotically, so to speak. It's a freestanding order which could have even been granted either on its own or based on the finding of the judicial.
I can't remember now. I could have read one of the reference to a decision which said when the just and applicable remedy is ancillary to either the review and setting aside or the declarative.
Yes.
I think it's one, I can't remember.
Yes, it's the magistrate something.
I don't think.
The Lord, can I assist the court?
Yes.
The McBride decision of the High Court, which is now heads. That's the case your lordship has in mind.
Yes, and in fact I've got it. Yeah. Let me explain what is said. This is what I've just been addressing now, as to whether the order, the second order, let's call it that, flows only from the first order, or whether it can exist, or it could exist on its own. Now, I'm saying, A, that order, remember when you look at an order, you must read the whole judgment. You don't just go to the order. You must look at the context. The context starts with part A, which I've just read out, which makes it clear that the basis for the conflicts were common law. In fact, that court went overboard by basically saying it was only the common law, and I've addressed that. It was wrong to do that. I've also addressed that point from the basis of saying even that this honorable court could have found against us, let's say, on the section 96 point and still come to the same conclusion based simply on the common law. That's the second point. I've addressed it thirdly by saying the could have come here and simply asked for the setting aside without any declarative or anything by anybody, and simply say she's seeking a setting aside of the suspension. So on those three grounds, it should be very clear that the existence of the order in 187.6 is not dependent on the order in 187.5 at worst for us. At best, it is not wholly dependent on the order in 187.5. Now, where does that then take us? It takes us to the following. The first, I'm not going to spoil Mr. Ngalwana's argument, but if with his permission, let me borrow one of the points that he makes. If that is so, then we have an order under 172.2. Then that order, at least let me start with my argument. Then that order is an order for the dealing with the conduct of the president. But then what must happen? That's the issue. Remember, all this is not just for academic purposes. It's to answer the question whether Section 18 applies. All right. Now, the fallacy of the argument from the other side is that they want to read only 172.2a. They don't want to read 172.2b. And that is really the total answer. Because 172.2b makes this very clear. It says an order of any conduct of the president and so on must be confirmed, what have you. And then it's A. And then at B, it says, and I'm going to read it because this is the crux of what I'm saying. A court which makes an order of constitutional invalidity. Let's stop there. In other words, there's only one court in this country that can deal with this matter under 172.2b. It is this court. So if we decided to go to Pretoria and say, no, we want the public protector to go back to work and so on, that court would say, but what are you doing here? It's very clear that it's only the court which made the order of constitutional invalidity that may deal with this. And so there are two arguments, mine and Mr. Ngalana's. Mr. Ngalana's is that that's exactly what this court has done in what I call the second part of the order in 172, or rather 187.6. Because this court has then given the second sub-order and said this order now. Right? So this court could have conceivably, well, setting it aside, but we're not going to give any related relief. But this court did give the relief. It said it's effective now. So on Mr. Ngalana's argument, then where's the problem? Because the court has pronounced on what must happen in the interim, so to speak, assuming there's going to be confirmation proceedings. The court said the effective date is now, and you can't change that. And but here, let's read on. Now coming to my take on it. They say this court, a court which makes an order of constitutional may grant a temporary interdict or other temporary relief to a party. Pause there. This court may grant an interdict or other relief to a party. Is the public protector a party? Yes. Is she seeking other temporary relief? 18? Yes. So again, whether you look at it, take it from the point of view of Mr. Ngalana or my point of view, there is no problem. Surely, but surely, anybody, any lawyer who is interpreting that, it amounts to this. Yes, the default position is in section 2A, but then it says, you never know what the circumstances might be. You might have confidence by the things, let's assume it's about a child or whatever. The child is gone or whatever, person or whatever, some emergency. And that's why the constitutional writers, in the drafters, in their wisdom, then empowered this court, which already knows the facts of the matter, which already is seized with the matter, and knows the dynamics, rather than some court in Pretoria, on my example, which we'll have to go back and say, and basically redo all those arguments. No, it says this court, not even the constitutional court, this court that made the order may grant other temporary relief. Unless if you're going to tell that section 18 is not other temporary relief. It is.
So if I understand the submission is this, where there is a declaration of constitutional invalidity, that order must be confirmed.
Yes.
In those circumstances, section 172(2)B is the equivalent of section 18 of the Superior Court Act.
Absolutely. No, I'm not saying it's equivalent. Yeah, well, it's equivalent, yes, in the sense that it does the same thing. Yes, I understand. But what I'm saying, Justice Nogu, is that the drafters of the Constitution were aware, must have been, you see, when anybody who drafts legislation puts a thing like this, you know what they're doing. They're just saying, we can't think of all the examples of what might happen. So they say you may get
well instances where it would be unjust to wait for confirmation.
Absolutely.
And in those circumstances, the court must be empowered to give an interim.
Absolutely. And that's why they even went, it could have stopped there, Justice Nogu. It could have said, may grant a temporary interdict. But the drafters of the Constitution realized that the relief sought in the form of an interdict. It can be the form of a Section 18 application, as we're here now, for example. So that's why they widened it to say, or other temporary relief. I mean, that can mean anything. It could be an pillar, it could be whatever. It can be wider than that. They could not have expressed it wider than that. And somebody is going to have to stand up here and say the other temporary relief that was envisaged in that phrase excludes Section 18 relief. What is that? Because Section 18 itself tells us that it is by definition temporary relief. If you go to Section 18, in all its incarnations, whether it's 18.1 or 18.2, the abiding words are the following. Unless a court under exceptional circumstances, the operation and execution of a decision which is the subject of an application for leave to appeal or an appeal is suspended pending the decision of the application or appeal. So that section deals with nothing but temporary relief pending the happening of something else, right? So in which world can we say that Section 18 postulates something different than other temporary relief? And then it says it may even adjourn the proceeding a decision of the Constitutional Court on the validity of that act. So in other words, pending, again, look at that word, pending, at 172.2b. So it's not you're going to give, in other words, if the correct, the relief here, pending a decision of the Constitutional Court on the validity of that act of conduct. That's why it's important where we started, because where we started, remember I say it's a 172.1, but I'm saying assume that I'm wrong. But this court is constitutionally empowered, temporary relief in the form of Section 18, pending a decision of the Constitutional Court on the validity of that act of conduct, if they are correct on their interpretation of the orders, which we dispute. But I'm at pains to go into this debate on the assumption that they are correct in their characterization of the order. I've told you the reasons, this honourable court, of the reasons why I differ with their characterization. But I'm saying, throw that all to the dustbin and say that, yes, what we're dealing with here is so-called ancillary order or whatever. But and it's one that needs to be confirmed, whatever. That's the answer. It lies in 172.2.
So it's a very important point that you are making, Mr. Mkhwebane, and I think we just need
to sit on it a little bit, yes.
So you are content to determine the matter on the basis 72 to apply.
Let me explain myself. Yeah. I'm assistance to the court, but by doing that, I'm not going to as the court. I have to stay on my course. I'm saying, Justice, let me summarize it. I'm saying the orders must be read separately. The order in 187.6 is a self-standing order for the reasons I've explained. And I say that order derives, among others, from the common law finding made by this court. And that's crucial, because this court did make the finding of actual bias. And
maybe I phrased my question clumsily.
Yes.
I think the applicant's case is still as stated in the papers. But if you're saying that if you are wrong on that,
I'm prepared. Yes, in fact, that's a better way. So even if I'm wrong on all those things, I'm saying then 172.2b. In other words, even if I'm wrong in everything I've said, 172.2b was designed for exactly this situation that we find ourselves in. Let's assume this court had said, Justice No, explicitly, which it didn't, by the way, and that goes to 5 awareness point. Let's assume the court had said, setting aside the suspension, another order. This order of setting aside up here is cannot be implemented until there are confirmation proceedings. Let's assume the court had said that. Unlike what the court actually did, which was to say it's effective now. And that's why I agree with Malena Transport. Because this court didn't keep quiet on the question. It answered the question. But I'm saying let's assume it answered it against us and said, no, it's not effective on the 9th of September. It will be effective in November or whatever the confirmation proceedings. Let's assume that was so. We, in terms of section 172 2B, justices, we would have been entitled to come here, right, and say, yes, we know that this is what you said, but here are the exceptional circumstances, what have you, and so on and so on. Please grant us other relief in the form of section 18, and you say yes or no. That's exactly the purpose of section 172.2b. Unless if anybody is going to say we wouldn't do that. If you had said specifically, this order shall not be implemented until such time that it's confirmed in the Constitutional Court, we would still be entitled in terms of 172.2b to come here and say, yes, we heard you. However, the public protector, whatever the facts are, and you would have to evaluate those facts. If you like them, you grant us the relief. If you don't like them, you deny us the relief. And everyone will be happy. So it's a waste of time, this whole, it's just smoke and mirrors, this whole 172 thing. It's a red herring. It really has nothing to do with the application before us. The third issue, which, if this doesn't put it plainly beyond any doubt, then is the following. We know that what has happened in real life is that the DA and the president have, well, the president simply copied what the DA was doing. Well, let's just use one example. So that what the DA did was to file hurriedly. Let's leave all those things about whether they did it hurriedly or not. Let's assume that they did it after 15 days. But what did they do? They filed a notice of appeal and what? Alternatively, notice of application for leave to appeal. Common cause. Right? Now, what? And again, we've said those notices are not genuine, they don't make all the necessary allegations. In fact, they are not properly before the court. For example, the section 19 application is supposed to state why you're not going to the SCA and going straight to the Constitutional Court. They didn't do anything with that because they were just rushing. So they left out all the requirements of section 19. But again, today, let's assume that it applies, assume that it complies, assume everything is perfect that they did. Well, let's go to the source, section 18. Because I'm at pains to make sure that this court is not waylaid into irrelevancies or fancy footwork, which is really all this is. This is just all this is an attempt, a very clumsy attempt to resuspend the public protector. This time he being resuspended by the DA instead of the president. But let's see. But even if you do that, you must do it properly. And I apologize for doing this. I'm now doing it for a different purpose. The last words. Section 18. Subject to subsection 2 and 3, and unless the court under exceptional circumstances otherwise orders otherwise, the operation and execution of a decision which is the subject of an application for leave to appeal or for an appeal is suspended pending the decision of the application for appeal. So, if there is an application for leave to appeal or an appeal, that's exactly what they have done. They have filed an application for leave to appeal or an appeal. So in which world then is what they have done? So they can't say what they have done suspends the judgment, and in the same breath say that Section 18 doesn't apply. Where's the logic in that? Because the real reason we know they did what they did was not for the love of justice. It was to secure a suspension of the order. But so they want to have their cake and eat it. So they want a situation where they do something with the aim of suspending the order. But what the law provides as an antidote for that thing that they've done, which is Section 18.1, must not apply. That's like wanting to fight somebody in a boxing ring, but they must be, their hands must be tied at the back so that they can't hit you back, basically. That's what they're doing. Because how can you have it both ways? How can you have it both ways?
As I understand, what they seem to be saying is that the effect of noting an appeal or applying for leave to appeal in respect of an order which is subject to confirmation, it does not suspend because that order is incoherent.
Good. If that's what they're saying, then I'm going home right now. Because if that is true, then we're dealing with an inchoate order. We're dealing with an order which is not a final order. Then what are we doing here? Because that situation is covered in Section 18.2 of the Superior Courts Act. It says, subject to Section 3, unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision that is an interlocutory order not having final effect of a final judgment, which is the subject of an application for leave to appeal or an appeal, is not suspended pending the decision of the application or appeal.
No, but then they say that that scenario does not apply here because here what applies is Section 172(2)(b). So the applicant could only come to court to say there is this incoherent order, but I can't wait. So I seek this interim relief or interim interdict, and that applicant is not done.
That's true. That's what we're doing here. That's what I'm busy doing right now.
They say you have come under Section 18, which does not apply. It's Section 18 of the Superior Courts Act. But in these circumstances, you could only come under Section 172(2)(b). But I'm just putting the
no. I understand. That's why I'm saying
so that we can engage.
I accept that, but that's the absurdity of the argument. Because they're saying we should come here under 172(2)(b), and I'm saying here we're here under 172(2)(b) to seek other temporary relief. So that's that's why I'm so indulgent on this argument, because if they are right in all of that, then I'm saying you have to then say two things. This court would have to make something dramatic. It would have to say that the words other temporary relief in 172(2)(b) do not include a Section 18 application. I don't know on what basis you can say that, but it would have to say that first. Secondly, it would have to say the words appeal and application for leave to appeal in Section 18 do not include the appeal that they have put. I mean, so in other words, you'd have to say the words appeal in Section 18 have a qualification that we all don't know in the whole country. That actually you have to rewrite Section 18. The court would have to rewrite Section 18 and say which is the subject of an application for leave to appeal or an appeal, except for an appeal that is brought under Section 172 by the DA and the President. I don't know, something like that. You'd have to rewrite the section. In other words, you'd have to qualify the words appeal and leave to appeal. Because an appeal is an appeal. That's what they've done. They have appealed, right? So the section 8, whether you look at it from the point of view of section 18 or look at it from the point of view of 172, you come to the same result, which is that if you look at it from 172 point of the vintage point, then you say this is exactly the temporary relief is what we're seeking here. If you look at it from the point of view of section 18, then you say the word appeal means appeal. And what did they do? They appealed.
But didn't they
So-
appeal, sorry,
I'm sorry.
didn't the DA appeal to the Constitution,
Yes.
not to this court? So how can one use an appeal lodged in the Constitutional Court? Justifying people to get.
But there's no appeal here.
There's no appeal on the basis there's no appeal
Yeah.
before us.
Yes, there's no appeal. That's not up here. Let's just be clear. There's no appeal here. There's no appeal in the SCA. There's just an appeal which they have, according to their logic, lodged in the Constitutional Court. That, Justice Francis, is exactly what is envisaged in 172B, if you read into A. Right? What does A say? It says the thing must be confirmed not by this court, but by the Constitutional Court. Right? Then you must go to 172.2D to clarify that question. 172.2D is the answer. It says, any person or organ of state with a sufficient interest may appeal, or underline the word appeal, or apply directly to the Constitutional Court to confirm or vary an order of constitutional invalidity by a court, which means this court, in terms of this subsection. In other words, the empowering section that allows them to lodge the appeal is 172.2D, on the basis they are any person or organ of state with a sufficient interest. For present purposes, they are a party, so they're a party. So the point I'm making, Justice Francis, is the following, and that's why it's there's no jurisdiction issue. When we come here, let's say, for example, they were appealing to the SCA, right? Which they would have to do because this is from a full court. And then just the right thing, not this other stuff that they did. Let's say they did the right thing and say on day 15 or whenever. We're happy with this judgment, we're appealing it in the SCA. Then what must we do if we want it to be executed? We can't go to the SCA, we'll come here and say, in terms of section 18, this court must give us a section 18 order. Now, you can't then say, no, but they are in the SCA or the Constitutional Court or the Court of International Justice. It doesn't matter. The point is, an appeal is an appeal. The effect, and that, unfortunately, I don't know if the Tassima case, if I may actually just hand up some of our authorities, unfortunately, they are this morning from Johannesburg, so I'm not looked at them. Somewhere there, and again, to save time, is the Department of Transport versus Tassima. You'll find it's page 95 of that bundle of authorities. You'll see there's a discussion. I think it starts from paragraph 2. I want or the court with it. It's up to 40, up to about 50, where the court discusses the Tlameza case, one of the leading SCA cases on this. Yes. Let's go to paragraph 49. This is what the Constitutional Court said. It is, sorry. Yes, it is now apposite to revert to a consideration of the import of Section 183, I'm sorry, Section 18.3 of the Superior Court Act.
Sorry, paragraph, what paragraph?
49, my lord.
49, yes.
Page 101 of that panel we just
I've got it.
So, but what this court is called upon to determine in the conduct of this case is the import of 18.3. In particular, this aspect of the case raises the question whether an order made under 18.3 retains its legal force beyond the date of the decision of the appeal that finally determines the dispute between the protagonists. To answer this question, it is necessary to emphasize the point that all the subsections of 18 are interlinked and therefore to be read contextually. Let me just pause there. The conventional wisdom, which is correct, which was set out by Justice Francis in Mkhwebane and confirmed by the Constitutional Court here, is that if once you get the Section 18 order in the lowest court possible, the one that made the decision, let's say it was one single judge, the purpose is to suspend that order, and the appellant can go all the way. They can go, let's say, to the full bench here, if it was one judge, but it's still suspended. Go to the SCA, it's still suspended. Go to the Constitutional Court, it's still suspended. Why? Because an appeal is an appeal. So if the section says it is suspended pending an application for leave to appeal or an appeal, so it doesn't matter where that appeal happens to play itself out, as it were. That's the import of what the Constitutional Court was saying. It goes on, but I'll try and save time. If necessary, I'll deal with it in the plan. But so there's no issue really, whether it's in the Constitutional Court or the SCA and so on. In fact, that's where by the definition, when it's called an appeal, it means it's in a higher court. It can be an appeal from the same level. So by definition, an appeal is in a higher court. So okay, let's just then go back to the point I was making. In fact, I think I'm done because as I said, let's keep the eye on the ball. What is the ball? Does Section 18, is there any, let me put it in the negative, is there any reason that we can think of why Section 18 does not apply, or why Section 18 is excluded from the other interim relief that is envisaged in 172(2)(b)? The answer to that is simply no. And as I said, you can look at it again from the other side. Is there any qualification to the word appeal or leave to appeal in Section 18? And the answer is no. And I'm happy for the court to look at it from whichever vantage point, because the result is exactly the same. So the Section 18 applies, there's no doubt about it. The only, if I were I'm not here to give them free legal advice, but what they could be saying is to say that when the court grants the relief, if the court says we're granting it with Section 172(2)(a) to be read with Section 18, as we are saying, then they can say, well, it must be pending the confirmation proceedings and so on. That if I was them, I would meet that argument, but it's not the one that is made here. So I'm not going to waste time on it. Yeah, so the question of applicability of section 18 is very clear. Let's now go into the merits. And you see, this matter, you have to look at it in its true perspective. The reason why we are distracted with these gymnastics about whether section 18 applies and so on is simply because there is no answer to the section 18 application. And I will demonstrate that now. The actual section 18 application, for all intents and purposes, is unopposed. And I will explain that, and I'm not exaggerating. Because they had no answer to the actual section 18 application, they had to find all these fancy. That's why we say in our head, clever by a half. The 172 argument is clever by a half because you just dig yourself into the hole of the actual interpretation of 172 and section 18. Now, why is this? Why am I saying it's unopposed? Right, this court, I'm not going to bore the court by dealing with the test in detail, except to say this. I've learned this dealing with section 18. In fact, one of my opponents, let me say, learned it the hard way because they pleaded only what I call the statutory requirements, the 3 statutory requirements. And this was a matter that involved some mining matter. I'm digressing into it for a purpose. And as the court knows, so we had succeeded with the one judge, and then they appealed under the automatic appeal provision. And then they went on exceptional circumstances, no irreparable harm, and irreparable harm on the other side. And all we needed to do was to go to the, I think it was Justice Park, was presiding, was simply to say, well, yes, those are the 3 requirements, statutory requirements, but the courts have now infused a 4th requirement effectively, which is the issue of prospects of success. And the court said, where have you pleaded that? And they pleaded it, and that was the end of it. I'm saying that in aid of the following. Forget the statute for now. Well, don't forget it, but read it together with the rest of the law. You might remember that when this was still, section 18 was regarded as a novel invention back in 2013, 2014. Because we had just migrated from the South Cape case and Rule 4911. And one can never understand this without always going back. In the case of South Cape and Rule 4911, the distinction, okay, I want secrets of my team. But I was talking about this regarding the essence of what Section 18 is about. Section 18 is a departure. The only thing really that Section 18 has done is to depart from what we all used to do until 2013, which was to go to court and say we must do a balance of harm. You remember that expression? It was called balance of irreparable harm. So prior to this intervention by the legislature, you had to come to the court, this court, and say that the harm that I'm going to suffer if you don't grant this is more than the harm that the other side will suffer, right? The legislature intervened decisively. So we no longer, that's spelled out in Kemeza, spelled out in AfriForum, it's spelled out even in Tassima. We no longer do a weighing exercise. What the legislature has done is now to separate the tests. You have to prove that you will suffer harm, and you have to prove on the balance of probabilities that the other litigant will suffer no harm. So it's no longer, there's no weighing exercise anymore. It's this one will, in Clemens actually is underlined in SNAPSA JA, underlines the word will and will not. And that is what we know in the business as the heightened test. That's really all that has happened. It has now therefore introduced the heightened test on the part of, because, why is that so? Because it has been said that this is not an ordinary remedy. The default position is that the winner must wait, basically. And, I explained this to my daughter, who's not even a lawyer, and she understood it. To say that if we're fighting about a pen, then I win, and the pen is supposed to come to me. And you put an application for leave to appeal. If you had the pen, then you say, oh, well, I'm keeping the pen until the appeal. Why is that so? It's for a good reason. Because what would be the point of giving it to me, and then I use it and I write and I finish it, then you win some appeal a year later. So the law, the default position is that it must stay where it is until the appeal is. But I said to her, if I can go to the court and demonstrate that there are exceptional circumstances, that I will suffer harm if I don't get the pen now, and you will not suffer harm because you have 1,000 other pens, but for me, that's my only pen. Then the court will say, okay, you Mr. Boff, you can have it. That's all really. That is all. So the default position, all the law said is that this default position must be departed from, not so much after the so-called weighing exercise, but the test is higher now. I must show harm on my side and no harm on the other side. That's all. So where are we then? Taking it back to this. We have said, and if the court wants us to, again, I don't want to waste the time of the court, but if there is a case that has exceptional circumstances, it is this one. This case, all that anybody has to do is to read the judgment and understand, and I'm sure my learned friends are going to deal with that extensively because they feel strongly about it as parliamentarians. But let me just give you some of the highlights. What have we got here? We have a situation unprecedented where the president of a country, what Mkhwebane CJ called the highest raw state power, has, according to this court, abused that power, acted improperly, actual bias, also reasonably apprehended bias, also a breach of section 96(2), because this involved his personal interests. That's what we have here. Now, we are told that those circumstances are just, usual. This happens every day.
What is the argument that the exceptionality of the circumstances must be relevant to why it is that the default position is departed?
Well, firstly, I don't know where that comes from, but yes, that was the argument. But the argument is very simple. That the law is very simple. That and it is what we have put in as a preamble in our heads, so that it's clear. And this is the relevant, or how relative, or maybe I'm calling it. So this statement has been endorsed by all the courts from Southern and J in Quebec. It says, necessarily, in my view, exceptionality must be fact specific Okay, that's the first thing. The circumstances which are or may be exceptional must be derived from the actual predicaments in which the given litigants find themselves. Who are the given litigants? It's the public protector, the DA, the president. The primary, actually the primary litigants is the president and the public protector. The other parties have joined one side or the other. Really, it's just now we've got the tail wagging the dog, so to speak. But that's a story for another day. So the actual litigants, for the purposes of this, again, let's assume that the DA is the primary litigant. All that is said here, Justice, is that exceptionality must be relative to them. I'm saying, I'm talking about one of those litigants called the president, right? And I'm saying what has been found here, just dealing with the issue of exceptionality, I'm saying that it is the most exceptional thing to happen. We have said in the founding affidavit, this case is even more exceptional, to use that word, than the EFF Nkandla case, which it follows. And when we say that, we're saying it's a tool of analysis. So we're saying, for example, if you think that the Nkandla circumstances were exceptional, then it's not logically possible to think that these circumstances are not exceptional, because these are 10 times worse than what was found. I've already alluded to the fact that Nkandla was only about the low threshold in section 96(2). There was no final bias there. The finding of there's no finding of the malafides, an improper motive or ulterior motive. It was simply an appearance, a risk of conflict sufficient to realize. Here we have the worst end of the spectrum. If this is a scale of 1 to 10, Nkandla is at 1 or 2. This case is at 10. Full throttle, because it's got everything. What can you be guilty of? 96(2). Apprehension of bias, actual bias, ulterior motive, bad faith, and the state machinery. And I'm saying this. Let me make this statement, and I'm making it boldly. This case involves abuse of state power. Nobody's mind can dispute that statement. But what abuse of state power, and of abuse of state power, which amounts to the highest form of corruption. Because there's this notion that this case does not involve corruption. When you abuse state power, whether you are taking a bribe as a traffic police person, or giving a tender to the wrong person, or suspending the person who's supposed to investigate you, all of those people are doing exactly the same thing, justices. They are abusing power that we gave them as citizens for personal gain. That personal gain might be 100 Rand in the traffic cops example, might be 1 million Rand in the tender person, and it might be whatever amount it is here in the Pala situation. If you don't believe me, you must believe the Constitutional Court. Because this is what the Constitutional Court said in the United Democratic Movement, the Speaker of the National Assembly, 2017-5, SA They've got the Roman. It says SAZ, ACC at paragraph 6 and 7. I'll give you the law report citation. I think it's 2017-3 SA, page 300 CC. But if that is not the correct citation, I'll give it now. This is what, in that case, I hope this time Mr. Buckland will learn, because he was my engineer. This is what the Constitutional Court said. This is the so-called secret ballot case which we did in the Constitutional Court. And it explained the linkage between abuse of power, abuse of resources, state resources, power that you have been given in that office, and what I call effectively corruption. This is one of the most profound statements ever made in our courts against this kind of corruption. It was directed at the president. You'll find that, my lords, at page 12 of our heads, paragraph 45. And I'm going to read it slowly because it's the heart of what I was saying. The president is an indispensable actor in the proper governance of our republic and bearing important constitutional responsibilities. And I jump some parts. Then it says public office in any of the three arms comes with a lot of power. That power comes with responsibilities whose magnitude ordinarily determines the allocation of resources, money, for the performance of public functions. The powers and resources assigned of each of the arms do not belong to the public bearer of the office. So there's some that protector there as well. Public bearers who occupy positions of high authority therein. Let me just repeat that. The powers and resources assigned to each of the arms do not belong to the public office bearers who occupy positions of high authority therein. They are therefore not to be used at the advancement of personal or sectarian interests. Amandla awethu, manda diashu, matakiarona, or matimba yaina. Power belongs to us. And Maibuye Africa, restore Africa and its wealth, are much more than mere excitement-generating slogans. They convey a very profound reality that state power, the land, and its wealth all belong to we, the people, united in diversity. These servants of the people, are supposed to exercise the power and control these enormous resources at the beck and call of the people. What the Constitutional Court was saying there is that if you are given power to be the license giver, the tender giver, or the traffic police person, that power does not belong to you. It is state power. And it comes with resources that we all invest to make you the president or whatever office you hold. And we put millions of money and prestige and all that around that office. That power should only be used for its intended purpose. Once you use it for personal gain, you are stealing our money, right? You are taking away what we said. We are giving you 100 million rand so that you can grow some forests or whatever it is. And you take that 100 million rand and you use it for personal gain. That is theft and corruption. That's what this passage is. Now, if that is not exceptional, even when it is performed by the highest office in the land, well, then we can all go home and it's fine. Then we'll accept that.
But how does that answer the question as to why can't the applicant wait until the appeal? because I think that's
Yes, okay, let me come to that. Okay, let's take a word, Justice Mkhwebane, wait, right?
I borrowed it from you from your example
No,
about the
that's
pen.
fine. No, I'm okay. I'm taking it back. I'm saying let's actually let's share it. Wait where? That's because that then touches on the issue of harm, Justice Mkhwebane as well. Wait where? She must wait in the condition of being suspended. That's where she must wait. She must wait in the degrading and undignified position of her dignity being vilified. She must wait where her reputational rights are being infringed. She must wait where her rights to work and practice her profession and occupation is being taken away from her. That's where she must wait. Or, and the point I was making, Justice Nogu, because I was coming to that, is that who is this person who must wait? It is the person who is the victim of the most egregious abuse of power ever seen in this republic. That's and we say, no, it's fine, she must wait. And the person who says she must wait is the person who put her in that position. So effectively, what we are then saying is that the victim of the abuse that I've just described now, of the corruption, of the theft of public money, the target of that abuse of the highest form of state power must wait.
Right, Mr. Bob, we are going to take a tea adjournment. May I ask that during that tea break, you now amongst yourself agree as to until what time so that
Yes.
we can
We will do so. How long is the break?
We'll reconvene at 11:30.
Let's cut this.
Yes.